Good afternoon. I'm here with Cruz Garcia Vallejo, who will be having a session today around data protection law for educators. And we'll be asking the question, how much do you think you know? So over to you, Maricruz.
Okay, thank you, Johnny. Good afternoon, buenas tardes. Thank you very much for joining this session. Before we start, it's just to let you know, I'm not myself an expert in data protection law. And it would be very pretentious to me to say that I know everything about data protection law. I am a digital learning expert or learning technologist or educator, like I imagine that most of you that are joining the session. But I think during the last year, I was involved in data protection impact assessment, which is something I'm going to talk about in my presentation. And I was I have the honor and the privilege to work with our information governance department and our data protection officer in the institution I am currently working with. And I learned a lot about data protection. And I thought, well, the latest changes that has happened and the impact that they have when we assess learning technologies, when we recommend learning technologies, when we use learning technologies with our students and our staff, I thought this is something definitely that my fellow educators and colleagues should know. And I am very happy to have this interactive session. Don't worry, it will not be me talking about data protection law, but I'm very happy to have this interactive session to raise awareness and to raise debate. And just to let you know that just always contact your data information office, your data governance department. That would be the key message from this session. And I must say, well, at this very moment, and for this interactive presentation, there are two technologies that are new to me. One is StreamYard, that I have a first session with Emma on Monday, and this is my second session. And on top of that, before knowing StreamYard was the software used for this conference, because I was expecting Collaborate Ultra or Teams, I have the happy, and I don't know if brave idea of having a interactive quiz using Turning Point as the tool for the quiz. Sorry. So I'm going to run a presentation in a small laptop using two technologies that one of them is relatively new, and the Turning Point I have practiced over the weekend. But I cannot see both screens at the same time. When I go to PowerPoint to launch a Turning Point, I will not see this screen. So if there is something which is not working, or the screen stopped being sharing, or you have an issue, you can hear me or something, please shout at me, because I will not be able to see the chat. And I think I think there will be time for answering your questions if I can at the very end of the session. And I think without further ado, I go now to my PowerPoint presentation. You are seeing the first slide. Just a couple of things of operational points I want to make. We are going to use an interactive quiz using Turning Point. We will do the quiz first. You will be able to see what is the right answer. There is only one right answer. Is true or false, or choose the right answer. If Turning Point does not work in your end, you don't need the app. But if Turning Point does not work in your end, don't worry, just write down what you think is the correct answer of the quiz. And when we finish the quiz, we will go through the answers, and I will give you some feedback and some information about data protection law and the last updates. Hopefully we will be in time. We will be finishing in time. And now, without further ado, let's start the quiz. As I say, let's go to the quiz first. We see the correct answer, and we go through the explanation later. And you don't need the ad of the Turning Point for those who are new. You just type the URL I am showing in this slide. It's www.ttpol.eu. And you will be asked for a session ID. This is the session ID. If you can open Turning Point or it doesn't work to you, just write down the answers. And now, finger crossed, the poll will be running. I have started, sorry, I just going through the poll as well. Sorry, my apologies. It looks like it's not picking up the Turning Point app for whatever reason. That's why we have the initial issues. So I just want to try again. I'm going to try last time opening the PowerPoint, but if not, I have a plan B, and I apologize for this, which is using a PowerPoint presentation with no Turning Point quiz at all. It's just a normal PowerPoint presentation. So let me just go through this one more time. Through this one. No, it's not running. So what I think what we are going to do is we are not going to use Turning Point, and I give you some time to write down the answers and the correct answer, and then the presentation will show the correct answer, if that's okay. Okay, so I just want to share again and the presentation. I'm sorry for this. Again, I'm just. So for a reason, I think I will have to restart the laptop. I'm not going to do that. So what we are going to do is I am going to give you some time so that you can write out your answers, and then you will see the correct answer. I hope everybody is happy with that, and I hope you are seeing my screen. John, if you can let me know if my screen is being displayed and everybody is okay with that. Hello? Everybody?
Yeah, the screen is there, certainly there. Maricruz, I can see it now.
Okay, because as I say, I cannot see the chat in the laptop screen. So, well, this one, I think also already that the correct answer is the D, because I accidentally revealed that one. So we go to the second question, which is according to the Data Protection Act 2018, who would be legally responsible for complying with the new UK General Data Protection Regulation? So I give you a couple of seconds so that you choose. And the answer is the data controller, and we will see the explanation later. So the third question, when students complete an online survey on digital literacy, they have the right to, if you want to select the right answer, what you think is the right answer. And the right answer is A, be informed about how the data are being used. Question number 4. When we use learning technologies, these learning technologies must never be used to record spatial category data, and because only certain systems can record spatial category data and with a special authorization. And you need to choose if the statement is true or false. And the correct answer is false. Question number 5, and I think I'm not going to read the questions because I distract your attention, and I want you to read the question and to decide which is the right statement, if it is true or false. And the correct answer is B. Question number 6. There is only 7 questions for the quiz, and this is this question and question number 7 are the most complex questions. I'm keeping an eye on the time, but these are the most complex questions. So I'm going to give you just additional seconds so that you can decide and you can read the 3 statements and choose. Don't worry if you don't know the right answer, because we will see all the questions. And I'm gonna now reveal the correct answer, which is question number 6. As I say, this question and the next one are complex, and we will go through the explanation in brief. And finally, the last question. And the correct answer is question number A. Nothing has changed until the UK loses its adequacy status for the European Union. I'm going to stop sharing my screen for a second, because I want to go back to the StreamYard window, and I want to know through the chat. Apart from this technical issue that we couldn't use Turning Point, I have my whole family testing it over the weekend, and now it didn't work. But apart from that, how do you find the quiz? Easy, difficult? As you saw, I chose examples that are relevant to our daily activity as a learning designer, as learning technologies, as digital educators. So could you just comment through the chat how you find the quiz easy, not easy? I know some of the questions are tricky, and I must say this quiz has been checked by our data protection expert. And you might think some of the questions were right to me, but there is always a little detail that made the question wrong. But I would have failed the quiz myself, I must say, but I'm glad that our data protection expert provide feedback and review the quiz. So can you just through the chat, I imagine, I don't know if they can, participants can use the microphone or no, but I imagine they can, but can you tell me, did you find the quiz easy? Did you find the quiz difficult? I don't know. Yeah, that's the...
Yeah, I mean, I was looking at the commentary of people who were answering the questions in real time as they were answering them, and I think it would be fair to say not 100% of people got them right 100% of the time. I think that would be a fair summation. So, yeah, I think people would have found them to be difficult.
Yeah. Yes, I think, well, some of them, they were easier than others, but the last two, I must say, I have to research myself, and I have to look at several documents I'm going to share with you. But I didn't pretend that you knew all the answers. And as I say, I'm not an expert. What I wanted is that this session is like for raising awareness, so that to raise debate, so that you know about data protection law, about what the changes that are happening. I must say, before I discuss the feedback or the results with you and give you the explanation, the questions and the answers, the legislation or the provisions I'm going to give you are in vigor at this very moment and this very month. It might be that in January, in the next 3 months, in the next 4 months, they are incorrect. There are some changes, because I do know that there are changes coming. There is a possibility that the United Kingdom might lose their adequacy status. There's something that my data protection officer told me, but we are now focused at that very moment on what is correct and what is in vigor at this very situation. So now I'm gonna go to share my screen with you, and we are gonna go through the explanation. And I just sharing because I share my the PowerPoint screen with you. I don't see the chat. So, Johnny, I think you tell me if my voice fades or the screen there is something wrong or there is a question in the chat that I should look at. Please do give me a shout and let me know.
Absolutely.
So, yeah, and I am conscious of the time as well. So I just tell me when it's 5 minutes so that we need to finish. I think this is the first question, and I think this is the easiest one. I just wanted to give you an overview of what is the main data protection legislation currently in vigor, which is the United Kingdom General Data Protection Regulation, which is very much the previous European Union General Data Protection Regulation that has now been embedded and is retained as a domestic law, but the United Kingdom has now the independence to have this legal framework and the review, and the government can make changes. And is the UK General Protection Regulation alongside with an amended version of the previous Data Protection Act. This Data Protection Act has 3 parts, as you know. Only the second part, general processing, is relevant to universities, to colleges, institutions, and to very much to us. There has been an amendment. There is one of chapter 3 of this part that has been changed because now we have the UK General Data Protection Regulation. But I don't think I'm not going to go into details because they wouldn't be relevant to our daily work. So it's so that you know that this is the main legal framework. That was the explanation which I have just been told you. These are the 2 sources that I would like to share with you, and these are the 2 sources that I had been using for the whole interactive quiz, which is the government page on data protection and the United Kingdom Information Commissioner Office, which is something I don't expect you to go there, and I don't expect to read obviously everything which is there, but keep those 2 links as reference points, because if you work in data protection and you have to do data protection impact assessment, you will probably will need these 2 links. So now we go to next slide. And this one, according to the DPA 2018, who would be responsible for complying with the UK GDPR? And the answer is the data controller. And let's see why. Well, these are the legal terms defined by the DPA. So the controller is the institution, the authority, the body that decides the purpose and the means for processing the personal data. The processor is the agency, authority, institution, or body that processes that the personal data on behalf of the controller. In terms of, sorry, just gonna go to the, so just, yeah, who is legally responsible for complying with the UK GDPR legislation? The data controller are legally accountable, and I'm using the term legally accountable. The processors have also accountability if there is any data breach, but the entity or the body who is legally accountable and responsible for any data breaches that their processors might have done is the data controller. And in this case, if we work in universities, if we work in colleges, we are the data controller. So we would be legally accountable if any of our data processors have any data protection breach, if there is any breach in the data that we allow our processors to record, to save, and to process. And we also have the data subjects, who are the individuals whose personal data is collected. We have the term personal data, which is different than the term spatial categories data. Personal data is any data that can be used to identify an individual, either if it is directly or indirectly via a combination of factors. And I want to highlight the terms indirectly, because when you are working with learning technologies, I have seen a lot of course leaders and I have seen a lot of fellow technologists that they think it is not personal data because you cannot, it's not your name, your last name, or your address, but it can be a personal data when it records a particular characteristic or attribute of someone that alone or in combination with other attributes or characteristics can identify potentially that individual. For example, if you are recording the location or you are recording if someone is a British or no British citizens, by itself, that is not personal data. But if you are in a department in which you know there are 10 members and only one of them is not a British citizen, that could be then that record, someone is British or someone has a British passport or no, could be seen as personal data because you could identify which member of your department is that person. So that's why we need to emphasize that there are many data that we might record and use when you are using learning technology that could be seen and could be considered personal data as well. So question number 3, and this is a very common example. We have students or staff that complete online surveys. They have the right to be informed about how the data is being used. What happened with the other 2 questions? Do they also have the right or not? So what the data protection law and the regulation says is the data subjects, our students, under certain conditions, and I highlight these certain conditions that they are in the DPA, they have the right to ask their personal data and to delete their personal data. But this does not apply when the data are being kept anonymized, when that data cannot be therefore used to identify the data subject. It is very common that people think, no, data subject, students and staff always have the right to access all the data and to know their data and to delete the data. Well, this is true only partly and only under certain conditions. We don't have time now to see all those conditions, and I think that is how I had given you the link at the very end about data protection and the DPA, of course, so that you know under which conditions students and staff and data subject can be granted access to their personal data and can request that the personal data can be amended or deleted. Obviously, if you don't want to read the whole circumstances, always the data protection officer is the first contact person, and I'm sure he or she will know this very well. Question number 4. This is something also a common myth, a common misunderstanding, that in learning technologies we never and we never record spatial category data, and I'm going to explain what they are because only certain systems can do that. Spatial category data are data of very, very sensitive nature. If you can say, for example, someone's sexual orientation, someone's religious affiliation, someone, if they have any disease, any disability. So these spatial category data are protected by the Article 6, and personal data is also protected by Article 6 and Article 9 of the DPA. So they have like an extra provision to protect when this data can be recorded and when and how this data can be processed. It's a very common myth, and among technologies, I have seen that in learning technologies, we never record spatial category data because this is very sensitive. We don't do that. That's wrong. we do sometimes have to record a special category data, and we do that for the sake of equal opportunities. For example, we need to know if someone has a disability or no, or we can use technologies that allow us to identify if someone has a disability or no. And that's fine, provided we fulfill the requirements for storing and recording spatial category data. And what are these provisions? Article 9 states 10 circumstances or 10 assumptions under which we can record and process special category data. But usually, when it comes to learning technologies, we do that because the recording and the processing of the data, special category data, is based on explicit consent from the data subject. But be careful, because if this is we use learning technologies and record special category data based on consent, we need to provide mechanisms as well so that the data subject can withdraw their consents. So what we do in data protections assessment, or when we need to record special category data, is we use the assumption that the recording and the processing is in substantial interest and is necessary for monitoring and promoting equal opportunity, for example. Always, as an extra precaution, learning technologies can record special category data as long as the processing does not involve any of these two assumptions, that is carried out when the data subject has asked to stop processing the data and when can cause substantial damage or substantial distress to the individual. So as long as these two assumptions are not happening, learning technologies can record special category data as long as is under any of the 10 assumptions or circumstances described in article number 9. Question number 5, and just checking the time, I think I need to speed up a bit. We use, and this is a real example, online surveys, and we use experiments, and we think do not include personal data, so an impact assessment is not needed, and that's the wrong assumption. When we run a data protection impact assessment, when we collect or use personal data, when we use free software or software that requires approval, and obviously when the processing involves high risk to individual, assessment software always have a data protection impact assessment in place. When we use online surveys and online experiment software, even if we don't record explicitly personal data, we might record a trail of online interactions of the participants, and that could potentially help to identify specific individuals, and that's what a data protection impact assessment is needed. But always, when you buy new software and you use your software, always check with your data protection officer if a data protection impact assessment is needed or not, or which parts of the assessment will be needed. Question number 6. I think in this case, the answer is at this very moment, is question C. And I'm gonna go, I'm just gonna go quickly through the answer to this. This is what is gonna be the new legal framework and the new provisions for data protection law. These are the ICO has a public consultation that ended in October, and this public consultation document included a new risk assessment, risk transfer assessment and tool that is going to be used for transfer of international data with 3 countries like the United States. So, and also this consultation document include a new international data transfer agreement, which is a draft at the moment, And the expectation is that this new international data transfer agreement will be used for those services that involve the international transfer of data with other countries, and which countries that do not have the status of adequacy for the United Kingdom government. And I will explain what adequacy means in brief. Very important. Adequacy, I just tell you this, countries consider adequacy when the legal framework of that country, data protection wise, has been assessed and has been considered adequate to provide legal safeguard of the data. Is the United Kingdom government, the United Secretary, who decide which countries has adequacy regulations in place to consider that it's safe to exchange data with those countries. The United States are not yet in the list of countries that the United government consider adequate, so that would not apply. When that not apply, there is another legal mechanism, which is standard contractual clauses. And this is a mechanism that can also be used, and the ICO recommends to use this as a legal safeguard to comply with the transfer that the restricted transfer rules that supervise or that regulates the exchange of data between countries. When I use the term restricted transfers, is because in the ICO consultation document, they call this international transfer restricted transfers. This is a term that they introduce, and they explain restricted transfers are, for example, transfer between the United Kingdom and an organization in the United Kingdom and an organization in another country. And just to mention these standard contractual calls, the ICO provide a template to use those clauses if you want to use as a legal safeguard. This one, you don't probably have to worry so much, but the data protection officers in your organization, the translation of this is they might have to modify, and they are probably modifying the templates that you use at the moment, or the data protection impasse assessment, or if you are using data protection agreement with third-party countries which are not in the European Union, and they will have to make changes to incorporate these new dispositions. The last question, I think Johnny just told me we are okay, I just finished with that, is, well, in this case, the provider is within the European Union, is a European provider. So this is how the adequacy regulations came in place. This is for you. I'm gonna provide at the end of the presentation the link so that you can download. But I think for the sake of the time, you don't. I'm not gonna explain now how adequacy regulations came in place. Just to let you know, both the United Kingdom and both the European Union consider adequacy regulations, adequacy status, as the best way to transfer data between organizations which are in two different countries, as long as both countries fulfill this adequacy condition. So the United Kingdom has a list of countries that fulfills this adequacy decision. So the United Kingdom government stipulates and considers that the data protection law and regulations in those countries is safe enough to allow the transfer of data from the UK and to protect our rights as data scientists. And then when that's the case, you don't need a standard contractual clause, or you don't need extra data protection agreement. When a country is considered adequate, or when there is adequacy status, it's fine to exchange data from the United Kingdom. And I think I'm going to stop sharing now. As I said, I just want to see how is the general feeling through the chat and pick up things I miss. I just go. to share the screen with you, and just tell me, Johnny, if I mean anything in the chat about that, or you wanna? I don't think participants cannot talk. No, cannot
No,
speak.
they're unable to talk. Yeah, no. So there was. I think we were talking earlier. I think it's a complicated subject. I think it's difficult for everyone to have a handle on all of the conditions. One thing that did come up was Caitlin saying that she doesn't know how this applies to an EU country. So this is a layer of complexity over the top of what people think they know about GDPR, just because they're not entirely sure how we're affected post Brexit. And there was some lively discussion around what constitutes personal data. And Neil said it's images, voices, or personal opinions.
Yes, that's correct.
Yeah, and someone was saying photographs of hands, if they have identifying features or scars or fingerprints even. So it quickly, there were a lot of observations around that particular element of what you were talking about.
Yeah.
So, but in terms of questions, they were, your explanation was quite full. So I think people, found that adequate, and fulfilling. But there were just a few comments around that. So,
my last key point, and thank you all of you for bearing with me through the explanation. That is really, there are going to be changes coming. The way we do our data protections assessment might change, because it's likely we are going to have to do now, if we exchange with third countries like the United States, which are not have adequacy, we have to do something else. Our information governance officer, they will tell us. And I think the message from the European Union is, and I double check this with our data protection officer, if you use a provider which is in the European Union at this very moment, it's fine. You don't have to do anything, because we have adequacy status, both the UK and the countries within the European Union. The other thing is, please, if you use free software, or when you think by software through procurement, always run a data protection impact assessment. It's very common, and I did myself when I was teaching in university courses. I do use free software. I confess, I did not go through any data protection impact assessment, but that's an example of what you should never use. You might not have to do a whole assessment, just check with your information officers, but it's always good to have in mind this data protection kind of mindset, that we cannot use any software or any third-party software, which is always internet, without making sure that we safeguard the legal rights of our staff and students, our data science, and that the data that is recorded there is protected and is in well sense. I think to share the presentation with them, it would be through Alt, Johnny. So
or you could put it in the Discord chat, or if you put it in the private chat now, I can post it into the comments. Whichever way.
You mean the presentation, or?
I thought you meant a link to the presentation, or the presentation. Do it through Alt, yeah.
Yes, I do, but I have closed the just one thing, and people, I have the link here, so I might be able to share the.
If you share the link with me, and I can put it into the comments,
so that you don't have to.
Yeah. Well, thanks very much for that, Marie Cruz. That is a fascinating subject. But like all sort of paralegal matters, it does quickly get very, very complicated, as anyone who's got a passing interest in copyright will be able to attest.
So I just shared the link with you. Thank you, everybody, for joining my session. Thank you very much, and I hope you have enjoyed the rest of your evening.
Thank you very much, Marie Cruz. Hasta luego.
Okay, so just finish. Bye, everybody.